Okay. Okay, we'll start. Okay.
Yes, we can start.
Good afternoon, federal viewers. Today we have with us Apar Gupta, who's like a powerhouse in terms of being a internet rights advocate. He was the founder director of the Internet Freedom Foundation, and he's been responsible for landmark challenges on privacy, surveillance, censorship. He has worked on the Pegasus spyware and Aadhaar privacy bill and the Section 66A. So the striking of it, he had quite a lot to do with. So today we're going to ask him about the Karnataka bill. And do you think the Karnataka's bill gives a state fact run unit the power to label content as fake? Do you think this is like a constitutional overreach?
I think this is a constitutional overreach because it's important for people to understand that the Karnataka bill is not only creating a censorship power in the sense that if the Karnataka regulatory authority, which they're establishing under it, determines something is fake, false, or misleading, or saying that it's incorrect. Okay, so there's just a takedown on social media, like they remove a tweet or they put down an Instagram post. That's not what this bill creates the ability for the state government to this as I was saying, I'm sorry for the lag in my connection, but I'll just repeat it again. This bill is just not about takedown powers, which means that things are removed from the internet. This bill also creates a process how the state government can initiate a criminal prosecution against a person anywhere in India. And that's why it's a constitutional overreach. And if we talk about it a little bit more, the provisions of this law, for instance, have phrases such as something which is posted which is anti-feminist or disrespects Sanatan symbols. So I have argued in an op-ed which I've written that if Dr. Ambedkar today would burn the Manusmriti, would that be considered not as an act of social protest but as a disrespect towards Sanatan symbols? And arguably even the framer of our constitution would be within the purview of this law and there would be legal risk for his prosecution. I'm sorry, I can't hear you. I think you're on mute.
No, I was just saying it's a very interesting take that Ambedkar could be behind bars as per this new
Or at least
bill that's
prosecuted.
proposed.
Or at least prosecuted. Yes, like people could send
Okay.
complaints, right? Because I like, here's the thing, uh, we must think about this law from the perspective of going beyond political parties and their interests. We need to forget about whether this law ends up benefiting the BJP or the Congress or any other regional party also, which is in at a certain point in time um, in power in a state government, right? We need to think about this law from the perspective of the people the constitution serves, which are the citizens of India.
Right. And see, under Section 69A of the IT Act, only the central government can apparently issue takedown orders. So, do you think that a state is building its own censorship pipeline? Is this and do you think this is like a bad precedent for other states, like say UP or Bihar, to follow next?
Definitely, uh, uh, we quite often hear very alarming news reports of rights deprivations from uh, states which are part of the northern belt of India. But here it seems that Karnataka seems to be innovating on an authoritarian tendency. It may be coming from an intent towards curbing information disorder. So it's nobody's case that there's no fake news, there's no disinformation. It's not as if people are saying awful things online. However, what is the remedy? Is the remedy for a state government to have powers to direct platforms to take down content? And now what will happen quite often will be that a platform will not be able to take down that post only for Karnataka, right? It's not going to block it only for Karnataka. It will block it for potentially all of India, right? So even region based blocking, if it's implemented by Karnataka and other states adopt it, let's say four more states adopt it, they may be issuing orders which are very different Okay, they may be issuing orders which may only arise from determinations within their own executive branches, but the impact of those orders will be felt across all of India, which is why, as you referred, Rachel, Section 69A of the Information Technology Act states that the appropriate body, which includes the state government or the central government, can designate a nodal officer. So, for instance, if Karnataka needs something to be blocked online, the nodal officer within the government of Karnataka sends a request to an authorized officer which is nominated by the central government. And there's a committee which is called the blocking committee, which then determines whether the content should be blocked following the safeguards provided under the 69A and rules which were made in 2009.
Right. So, do you see any appeal process for content creators or journalists in this bill? And how do you think it violates the principles of natural justice?
So there are processes within this bill, specifically with respect to criminal prosecution, with respect to what will happen in a trial. So it is not as if you will be convicted without a trial. Those safeguards are there. But what we have pointed out, and here's the thing also, the bill has not been made public. So IFF received a unofficial copy. We confirmed it against the press reports, and it seems to be the authentic copy. But what we did notice was that it's not about the trial and the eventual conviction. Quite often, the issue is that the injury to a person who's an accused occurs because they are arrested before the conviction by the police for custodial interrogation. Okay, just to gain more evidence about the uh, the, the potential crime which they are investigating. And here, I think, Rachel, what's important for people to consider is that the court which is being set up here, which is a special court, can only give bail after hearing the state government and its opinion on that its opinion from the state government. So basically, the state government has set up an authority which will flag or receive a complaint. It will then forward the matter to the police, who will register a cognizable non-bailable FIR for misinformation. Subsequent to that, the case will then move to a special court constituted under Section 8, and there will also be a stage which will be a pre-trial stage in which a correction direction can be issued. So even before the case is completely led through evidence, trial, all those processes, the court can still say that take down this content. And of course, aggrieved parties can appeal all of these things, but there are very high thresholds which are being set. So it's almost as if the censorship power is being empowered and the rights of a internet user are being undermined.
Okay. Uh, that's scary. I also want to ask you about the portion that deals with repeat offenders. So, do you think, can you talk about the proportionality principle and how it applies to the Karnataka bill?
So the proportionality principle, which has been developed by the Supreme Court of India, is a doctrine which is utilized to judge the constitutionality of a restriction through law, which is usually a statute, which means a piece of legislation, or it is an executive order. According to the proportionality principle, if the repeat offenders are pronounced, the government determines when it has to do so in a case which is there is a significant severity. Now, the that is reasonable
I think
and is
the
in the least
internet isn't
restrictive
great.
manner in,
Okay.
and it's
Upper, you
in the
might have to
least
repeat
restrictive
yourself.
manner.
Upper, you might have to repeat yourself because I think like we didn't catch what you said. Like maybe like in short, if you could summarize like about repeat offenders. Okay. No, but he's not online.